Today. We are delighted to have this event organized with the Bucharest Bar. My name is Marie-Hélène Proux. I am the current president of the ICC Bar Association. And first of all, I would like to introduce our focal point for Eastern European states, Ms. Sylvia Berbeck, who I see is just connected now. Sylvia, would you like to introduce yourself briefly? Or you'd rather not? I'll introduce you. Sylvia has just been appointed our focal point, and she is in charge of establishing links with different organizations and bar associations across Eastern European states. And this is her first event after being appointed, and we're really, really delighted that she chose the Bucharest Bar as her first event. Sylvia works for an organization in Bucharest called the Association Pro Refugiu. This is a non-governmental association based in Bucharest that has a mission to protect and promote the rights of victims of crimes. So thank you, Sylvia. And without further ado, let's start today's session. I will be first. I'll speak first to you about the I'll give a general introduction about the ICC, the ICCBA, and then we'll move on to some more specific details about representation of victims before the ICC and defense representation. I'll introduce the speakers for today. First of all, Heidi Dijkstall will be speaking today. Heidi is a UK barrister and a US attorney with over a decade of experience in practicing before international criminal tribunals and human rights law, including the ICC. Her practice has involved work before the ICC, the ICTY, the Special Court for Sierra Leone, the African Commission, and Court on Human Rights and People's Rights in various UN bodies. Heidi is currently representing victims before the ICC in the situation in Afghanistan and the situation in Ukraine. And I will stop there, although Heidi's CV is a lot more full than I'm making it to be. And after that, we will hear from Ian Edwards about the representation of defendants before the court. Ian is a barrister at the Bar of England and Wales. And since 2009, he has been focused on defending in international criminal cases. He has represented or assisted in the representation of clients in a total of 9 cases before the ICTR, the Special Tribunal for Lebanon, the mechanism of the International Criminal Tribunals, and the ICC, and he is currently an associate counsel for the defense of Mr. Abdel Rahman before the ICC. And then there's myself, Marie-Hélène Proux. I'm a lawyer admitted to the Quebec Bar since 2003. I have spent most of my career advocating and practicing before international tribunals. I've also worked at the ICTY, at the Special Tribunal for Lebanon, at the Special Court for Sierra Leone, and I am currently a co-counsel in the case of Patrice Edouard Ngaïsona, which is undergoing trial at the ICC. I'm also not newly anymore, but I'm president of the ICCBA for a term of 1 year, and delighted to be here today. Just for a housekeeping reason, because we don't have a separate moderator today, we figured that it would be better to have questions at the end. So if you have questions throughout all 3 presentations, please don't hesitate to write them in the chat box or in the question and answer box. And once all 3 speakers have gone through, we will take questions. So let me now start with my own. If I can find a way to, I'm not so used to, excuse me, just 1 second. I should have practiced my my thing before, but let me see how I can share my screen. Dominic, how do I share a screen?
You just need to click on the green button that says share screen in the middle at the bottom.
Yes, you're right. Wonderful. Okay, that's great. Thank you so much. Now, I'm sorry, I don't know how to do this full screen, but that will do. So I'll do a quick introduction to the ICC Bar Association and to the International Criminal Court. So who is the ICCBA? Well, we are an organization that was created in 2016 and officially recognized by the Assembly of States Parties as the only association of lawyers practicing before the ICC. That recognition took place in 2019 at the session of the ASP. We decided to create this association because we felt that there was a need for an organization to advocate on behalf of counsel appearing before the court, as much as to provide specialized trainings around the ICC and its practice and its jurisprudence. We also provide confidential ethics advice and opinions to members. And we work, as today is an example of, on relationships with national and regional bar associations. We have, it's a big organization, the ICCBA. We have an executive council, which is presided by myself as president. We are assisted in everything by the work of our executive director, Dominic Kennedy, who has been here since the inception of the organization, and without whom we could not work. As you see, I couldn't even share my screen without him. The Executive Council is currently composed of 15 members, but from next election in October, it will be reduced to 9 members, including 2 representatives of support staff, people working with counsel. The Executive Council also has a vice president for victims, which is currently Heide, and a vice president for defense, who's currently Ian, and as well as a secretary and a treasurer. The Executive Council has the possibility to put together working groups to help on specific aspects that needs specific attention. For example, at this moment, we just created a working group on the crime of ecocide. We have another working group on harassment, who's looking into potential amendments of the code of conduct, and so on. And then, of course, we have our focal points, 5 regional focal points for all the regions of the Assembly of States Parties, and some thematic focal points as well on gender and diversity and on gender-based crimes. We have several committees assisting the Executive Council: the Defense Committee, excuse me, the Victims Committee, the Council Support Staff Committee. And as I was saying earlier, Council Support Staff means people who are not exactly at council level, but have less experience, but are still needed to work on legal teams here at the ICC and have specific needs and issues that they want to address. Then we have a Professional Standards Committee, which is the one tasked with providing the confidential advice I was mentioning earlier. Legal Advisory Committee, Training Committee, which provides trainings on several issues throughout the year. Our next one is actually on 17 June, just this weekend, providing a very specific type of training, a technical, that is quite highly relevant at the ICC and its practice. We have an Amicus Committee, which hasn't been incredibly active because it's can be quite tricky to provide amicus briefs on time when issues are quite pointed, but we still have that possibility to intervene as amicus on different proceedings. And then finally, we have the Membership Committee, who receives and assesses the request for membership. Our elections are held yearly at the General Assembly. The next General Assembly is scheduled for 20 October this year. The types of memberships, we have 3 types of membership. The full membership, which is automatic if you are a member of the list of counsel of the ICC, and I will later explain what is the list of counsel and how you can get on it. Then we have associate memberships, which is targeted at people who are on the list of assistants to counsel and people from the legal teams who are working on legal teams. And finally, we have affiliate members, which is basically open to anyone who has an interest in international criminal law and the practice of the ICC. We have members from over 70 countries around the world. At the moment, we are about 350 members, and it has been growing steadily in the last few months. From Romania, however, we only have 4 members, so we would be delighted if we could increase representation in your country. Our lawyers have experience representing defense and victims at the ICC and in domestic jurisdictions. They are also academics, students, young professionals. It's actually quite a vibrant and diverse community, which is quite stimulating to see and to provide opportunities for interactions. The ICCBA offers the possibility to different organizations to sign affiliation agreements with us. This would allow, the ICCBA and the targeted bar association or university to establish a privileged mutual relationship, to organize joint events and trainings. For example, we could think about an agreement whereby ICCBA trainings could be recognized as continuing legal education in different bars. We share expert knowledge on issues of common interest, and of course promote the highest standards of professional ethics. We have actually quite a few affiliation already signed with different organizations, and we're in the process of enlarging this number because it can be quite a productive way to work together with different bar associations. One thing that the organization unfortunately does not do is to guarantee a job at the ICC. This is out of our reach. The ICCBA is not in a position to offer positions within external legal teams or at the ICC itself. Some people actually think that becoming an ICCBA member will give them a fast track towards representation in front of the ICC. Unfortunately, that is not the case. The registry only is in charge of assigning counsel. This being said, membership in the ICCBA gives avenues in which knowledge can be acquired, connections can be made. It really is a good networking opportunity, which can then lead to eventually roles before the ICC. Now, the ICC itself. Well, you probably already know this, but let me go back to the basics. The ICC was established by the Rome Statute that was signed in 1998 and became operational after 60 ratification of the statute in 2002. Its role is to investigate and try individuals charged with genocide, war crimes, crimes against humanity, and aggression, although for that last crime, it hasn't yet entered into force. So it is not actually taking place at this moment. At the moment, the ICC has 123 member states. It has 18 permanent judges. These judges are elected every 3 years, 6 at a time, by the Assembly of States Parties. Excuse me. It has 3 principals: the president, who is elected by the plenary of judges; the prosecutor, current prosecutor is, of course, Mr. Karim Khan, who you probably have heard of. He was elected by the Assembly of States Parties; and our new registrar, Mr. Osvaldo Zavala-Giller, has been elected by the plenary of judges as well just earlier this year. He's just been in function for a couple of months. And then, of course, you have the external teams for defense and for victims. We are not represented by an organ at the court. However, we can benefit from the support of the Office of Public Defense, Office of Public Counsel for the Defense, and the Office of the Public Counsel for Victims, which are sections within the realm of the registry, but that are operating independently and to support defense representation and victims representation at the court. Now you see some numbers here on the screen about the types of number of situations, cases, etc., that have been taking place at the court since the court became operational in 2002. At the moment, there's only a handful of cases really that are going on at the court. 3 are stemming from the Central African Republic. One is a Darfur case that Ian is on, and one case out of Mali has just gotten into the deliberation phase. These are the cases that are at the trial stage, so that you are maybe the most likely to have heard of. All appeals, I think, at this stage have been issued, so there's nobody on appeal. And but however, I don't want to pass out the fact that a lot of cases are not actual cases. They're called situations. They're at the investigation stage. That's before an accused or a suspect is brought before the court. And there's a lot of work to be done even at this stage, especially in the representation of victims. But I suspect that Heidi will say a word about this a bit later. Now, practically, how do you become a lawyer before the ICC? Well, for that, you have to be admitted, to the list of counsel. And there's a number of requirements for this, which include 10 years of 10 years of experience in criminal proceedings. You must be fluent in English or French because these are the 2 working languages of the court. And then, of course, record of high standing, record of the profession, no criminal conviction, etc. Practically, this means that you'll have to fill out a form, and that's providing a few documents. Then you send your application to the registry. The registry assesses, and a few months later, you would get a notification that you have been admitted to the list of counsel. In parallel to that, there's also a list of ICC assistants, assistant to counsel. So these are a bit less, the requirements are a bit less stringent for these ones. You only have to have 5 years of criminal law experience and specific competence in international or criminal law and procedure. ICC list, the assistant to counsel are absolutely essential to the work of the court. While counsel probably get all of the, of the glory of being here, none of us could work without our assistants and our legal assistants and case managers, who are absolutely essential to the good working of any team before the ICC. It's never a one-person job to represent victims or defendants before this court. It's very much a team effort. And so, people of lower years of experience are also very much needed in the process. So as I was already saying this, I'm sorry, I anticipated on my own PowerPoint presentation. If you are interested in getting admitted to the list of counsel, you should go to the ICC website. The form is available there, and it's not a terribly complicated process, although it's a bit administrative. Just to give you a little bit more numbers, there's currently only 5 members of the list who indicate Romania as their domestic jurisdiction. Knowing that this list is composed of almost 1,000 lawyers, I think this is something that we should try and rectify. And hopefully today's will give you, at least some of you, the desire to be admitted on this list and to join this big legal community. So I will stop here because I am not the most interesting, I don't have the most interesting presentation for you today. I think I leave that to Heidi and Ian, who will delve into the more specific aspects of the work that we do here before the court. So without further ado, I will hand over the floor to Heidi.
Well, thank you so much, Marie-Hélène. And thanks everyone who is joining today. I'm very glad that you're interested in the work of the International Criminal Court and also the work of the ICCBA. And we hope to see that you also join the ICCBA as well, and would love to see you there. So I am going to be speaking about victim representation at the ICC today. As Marie-Hélène said before, I have been working at the court for over a decade on various issues, victims, defense, state interests, but a lot of my work has focused on victim representation at the court, and it's a unique aspect among international criminal tribunals that is of note. So let me start by just saying that the right to participate at criminal proceedings, and particularly international criminal proceedings, is something that had been discussed in the international sphere for a long time before the ICC came around. Thinking about such documents as the 1985 United Nations Declarations on the Principles of Justice for Victims. That was a concept that was discussed in this document. But it really wasn't until the ICC came to be that the participation of victims was advanced in the way that it was, that gave victims such an elevated right to participate in the proceedings. And it's unique to earlier international criminal tribunals in that it includes, through the representation of the victims through their lawyers, that the victims will be parties to the proceedings. It allows the victims to participate in the proceedings at each stage of the proceedings. That's as early as the preliminary examination, when the evidence is being vetted, to the investigation, onto confirmation of charges, the trial, the appeal, reparations. Victims can participate during all of those phases. And the ICC was the first international criminal court and tribunal to include victims as parties to the proceedings in this way. And notably, following that was the extraordinary chambers in the courts of Cambodia, and also the special tribunal for Lebanon, which subsequently also had a role for victims as well. So in discussing victim representation today, specifically at the ICC and how it works, I want to cover a few broad topics that discuss the overall structure and the manner, the approach at the ICC to victim representation. And then I'd be very happy during the questions and answers to address any specific questions you have about victim representation. I'm going to start by talking about the goals and purposes of victim representation. Then to talk about some of the key issues victims seek to raise at the ICC and how victims can influence the proceedings, and then also about the styles and approaches to victim representation at the ICC. So let's start with the goals and purposes of victim representation. As a starting point, victim participation at the ICC raises the question of what is the goal? What's the purpose of victims being participants to these proceedings? So the short answer is that there really is not one agreed purpose. For some, the argument has been that we must view the proceedings as no more than a criminal process. There's a charge that is brought, there's a defendant, and the proceedings are solely aimed at ascertaining the guilt or innocence of the defendant. So it's much more of a retributive justice, where the victims can see justice and accountability being done through an assessment on the guilt or innocence of the defendant. For others, the goal of victim participation is more restorative justice, with the aim of providing compensation and to try to make the victims whole through this process. And then still others bring forward arguments about how the proceedings serve additional purposes: to provide a historical record, to assist with peace and reconciliation in the area of the conflict, to allow the victims to tell their stories, or to allow victims to gain the truth about what happened to them or to their loved ones. So this last goal, a note on that about knowing the truth, is an example of how the ICC procedure can sometimes interact with other branches of international law, this one being international human rights law. With the evidence that the court, there's been quite a lot of evidence that the ICC is increasingly taking human rights considerations into account in the international criminal proceedings, and looking to concepts that are in international human rights law about the right to the truth for victims. That's increasingly an approach that an area that has been emphasized, and I think is enveloped in the representation of victims as well, and even at the ICC. Now, court officials themselves have also emphasized the importance of victims to the victim-centered. There's previous statement, or the previous prosecutor Fatou Bensouda made statements on the importance of within the Afghanistan situation, a victim-centered approach to that investigation. There's been officials on the Trust Fund for Victims who have emphasized the unique and innovative approach of victim-centered proceedings for reparative justice, so revealing some of the goals there. And the Office of the Prosecutor has even set out a policy paper on case selection and prioritization that promotes direct interaction with victims and victim associations at all stages of the proceedings, really focusing on how not only the participation of victims, but interacting with the prosecution as well is a priority and is a way that these cases develop. As far as these goals, so we've just reviewed quite a few different goals of victim participation. I do myself strongly believe that the proceedings before the court must maintain functions of a criminal tribunal first and foremost. So to judge the guilt or the innocence of the accused on the charges that are brought in order to guard against alternative purposes or criticisms of bias at the court, or that the court is being used as a political tool. So that being the primary goal before the court. But as a legal representative for victims, it is important to act in the best interest of your clients under this unique mechanism of victim participation. And in doing so, make sure that your clients have the opportunity to present their evidence to the court and to give them the best chance possible that their harm, their case, will be raised and addressed during the proceedings. So there is a focus on that as well as the victim representative. So I'm going to move on then to what are the key issues that victims seek to raise at the ICC, and how can the victims influence these proceedings? And I think when we talk about what issues are key to victims and how they influence the court, what you really do need to think about is what phase of the proceedings. I think it needs to be broken into two phases. So very much talking about first the early stages of proceedings of the court, so the preliminary examinations and investigations, and then thinking separately about the proceedings before the court. So once charges are brought against an accused person, then there's the proceedings of confirmation, trial, appeal, moving on to reparations afterwards. But I think the approaches, the issues that the victims focus on and how they influence the court are really different in these two different phases. So let me first speak about the early stages of the proceedings, the preliminary examination, the investigation. And just to back up a little bit and give you some context. So as I said before, the preliminary examination is when a situation before the court, which Maria-Len had referred to before. So a situation is opened before the court about a conflict in a country or some potential crimes in a certain area and under the jurisdiction of the court. So at that point, the prosecution will be accepting evidence. They'll be doing their scoping of what information is available and really vetting at this point to see if it is suitable to bring it to an official investigation. So if it moves to that next stage, then there's an official investigation before the court that is open. The prosecution is going to be using more resources to investigate themselves, the crimes in that situation. And again, accepting evidence and reviewing that with a view towards potentially bringing charges for crimes that are under the Rome Statute. So, noting that the victims do have the right to participate at all stages of the proceedings, including these early phases. When we're thinking about what issues are key for victims, let's, starting with the early stages of the proceedings, let's, think again about how the prosecution at that point, so really where your focus is with the prosecution and not the judges, because the judges are not dealing with the facts at that point. So the prosecution is evaluating whether, based on the evidence before it, there's a reasonable basis to believe that crimes within the court's jurisdiction have been committed, that warrant arrest warrants. And so once to an investigation, the prosecution is formulating the scope of the investigation and where the prosecution is going to allocate its resources. So if you are representing a group of victims and you know that the prosecution is changing the scope or assessing the scope of the investigation and deciding on where to allocate the resources, what might potentially move on to a formal investigation or to charges, then there really is an interest when representing your clients to make sure that the prosecution knows about your victim's case and knows about these facts and will take it into consideration. And really the goal here is to make sure that the prosecution, when they're developing that scope, includes your client's case in what's brought forward. So, going back to what I mentioned before about the Office of the Prosecution's policy paper on case selection, and how it says it promotes direct interaction with victims and victim associations, then the goals of the victims and here are to make sure that the evidence of the harm that they suffered and the crimes that apply to them that are under the Rome Statute are brought before the Office of the Prosecutor. And there's a few different ways to do that, primarily through what's called an Article 15 submission, where evidence and information can be submitted to the prosecution for them to review. So I think that's a main goal during the early stages of the proceedings, and really a way that can also influence potentially the development, the way that the prosecution is shaping our case to move forward. So moving on then to the later stages of the proceedings. And again, this would include once there's been a charge against an individual, an arrest warrant that's been issued. If that person then is brought within the custody of the court and brought to the court, then there will be proceedings. There'll first be the confirmation of charges proceedings, then trial proceedings, appeal proceedings. And at that point, victim representation and the goals and the issues and influence that the victims have does switch a little bit. So now we're before the judges. There's proceedings before the judges. And at that point, the victims who are allowed to continue to participate before the court are those whose cases fall under the charges against the accused. So, to connect the dots between the early phase of the proceedings and these later phases, why it's so important to make sure your client's case and the evidence about the harm that your client suffered is before the prosecution is if the charges that are brought and then result in proceedings don't cover the harm of your clients, then they won't be able to participate at a later stage in the proceedings. So it's really important to really preserve their rights at an early phase and do your best to, of course, there's no guarantee the prosecution is going to take forward what cases they view as the strongest, and they have their deference on, doing your best to raise that and see if your client's case can be brought before the court in proceedings. So as to the interest of victims at these later stages, let's consider the way that the victims can participate during these proceedings, like confirmation, trial, and appeal, if they are then allowed to participate at that point. So the documents of the court, particularly the Rome Statute, the rules of evidence and procedures, set out that a party to the proceedings, the victims, through the representatives, have the right to do such things as present evidence during trial, to test the evidence presented by other parties, including cross-examining witnesses presented by the prosecution or defense, and to make written submissions on issues arising in the proceedings and to respond to written submissions from other parties as well. So looking particularly to Article 68 of the Rome Statute and Rules 90 and 93 that really set these things out. And on this note, some things like questioning of witnesses is a little bit more limited than prosecution and defense. It's not an absolute right, such that victim representatives should make an application to the judges to do this. So there are some limitations, but it really is quite a lot that can be done at those phases in victim representation. So again, as to the victim's issues and interests at trial, as a victim representative, the submissions made and the steps taken to test the evidence of the defense and prosecution should be done so in order to protect the best interest of your clients in the proceedings. So to try to ensure that there's justice and a remedy for your client's harm, and to ensure that your client's evidence is heard by the court. And that if there is evidence that supports it and it is moved on to trial, that there's a conviction which gives the victim a sense that there is accountability and justice and the possibility for reparations in the future. So I think this brings me, and I'm just going to, as a final topic, talk about style of victims representation. And how this affects the way that victims make presentations before the court. So I think that there's quite a debate in victim representation about whether victims act as almost a second prosecutor with legal submissions, or if it's more that the victims are there in order to raise their thoughts and concerns. And this really goes back to Article 68 of the Rome Statute that sets out that where the personal interest of victims are affected, the court shall permit their views and concerns to be presented. So that's really the provision that kind of allows that victim participation. There's no clear guidance on that or any decisions that decide whether the prosecution can take more of that kind of prosecutor role or more of just raising the thoughts and concerns about the styles. But I would suggest that it's best to probably do both. This requires a lot of communications with your victims. You have to keep the victims informed, explain legal developments, ask questions, and get written responses in order to both make those submissions on the legal points, but then also about how they're being impacted by the proceedings. And just realize that there's no set procedures. So the judges are not guided on how they address victim participation and what they allow. And that means that in every case, the judges have the discretion to address it differently. And we've seen that, just to give a few examples, in the registered vessel situation, the judges' approach here as to the scope of how much victims could participate and make legal submissions versus just raising the way that they're impacted showed that the judges in that case confirmed the rights of the victims to participate as in early stages of the proceedings, to make legal submissions. They had a wide approach to victim representation, and that's very much contrasted by the way that it's been handled in the Afghanistan situation, where the pretrial chamber particularly has taken a much more restrictive approach, and it said that victim participation has to be done through VPRS, and it's a section of the registry, and that the victims at that early stage of the proceedings don't have the right to make formal submissions through counsel on the legal matters, and also to raise their impact. So it's much more restrictive. So there's a lot of styles on that. But I do suggest that, in order to represent the best interests of clients, really trying to take that mixed approach of raising those legal issues, but also the way that the victims are impacted as well. And just to end, the importance of victim representation here, and I think that victims really are in this unique position where they get to speak to not only the issues of law and fact, but also their feelings and concerns on the way that they're being impacted by the proceedings. So they really bring this human approach, this human element to the proceedings, and have this opportunity to speak directly to the judges about the way that they're being impacted, not only on facts, but on proceeding, and really guide the proceedings, or I suppose have a substantial impact on the proceedings. So it's something that I think is quite a powerful position, and is unique to the ICC, and it should be fully utilized by victim representatives. So I'm going to pause there, and happy to answer any questions later.
Thank you so much, Heidi, for this great presentation. I would now like to give the floor to Ian Edwards, who's going to speak about representation of defendants before the court.
Thank you very much, Marie-Hélène. Yes, my name's Ian Edwards, and I'm an associate counsel, which is like a co-counsel for one of the defendants before the International Criminal Court at present. I represent a man called Ali Mohammed Ali Abdulrahman, who is accused of being a commander of a militia that operated in Darfur in the west of Sudan in the early 2000s. It's a case which is which has been progressing very quickly, certainly very quickly by International Criminal Court standards. The prosecution case started and ended in less than a year. The victims are in the process of presenting their case in the Abdulrahman case, and the defense are due to start presenting our case beginning in August. And I'll come on to that in a moment, because there's a bit of a question mark over how the defense is doing in terms of investigating its case. Forgive me if two things. I'm going to speak a little bit slowly. I hope that's okay. I understand that the participants in this conference understand English, but if at any point I go too fast, or if you have problems understanding my accent or anything like that, please let me know, and I'll repeat myself or rephrase what it is that I'm saying. I should also kind of apologize for the accommodation around me. I'm not on the moon. I'm in a tent in Cuba, in Guantanamo Bay, where I'm currently observing a trial that's going on here. So yes, I've been asked to speak about the role of the defense, and of course, defense counsel, the defense team, is an incredibly important feature of proceedings before the International Criminal Court, as in all criminal cases around the world. That we are here to represent the interests of an accused person, to represent them fearlessly and as robustly as possible. And this is all the more important because the very nature of proceedings before the International Criminal Court is such that defendants are charged with the very most serious offenses known to law, war crimes, crimes against humanity, genocide, and theoretically aggression as well. So of course it's vitally important that people who have been investigated, who have been charged, who the prosecution is pointing its finger at for these incredibly serious offences, are afforded the rights that are enshrined in not just international instruments, but the sort of rights that are found in all other jurisdictions around the world. I was going to start by talking a little bit about how one becomes defense counsel. Marie-Hélène has touched on that already. There is a process. It's not too complicated. The forms and the procedure are set out on the ICC website, as was already alluded to by Marie-Hélène. One thing I'll say is that, yes, to be lead counsel, one would need to have a minimum of 10 years experience in criminal law. But if you don't yet have 10 years of experience in criminal law, if you only have 8 years of experience, you can still apply to get on the list, because you can be appointed as an associate counsel or co-counsel. And Marie-Hélène also stated that, you know, anyone who's interested in working for the defense at the ICC, even if they don't fulfill the criteria to be counsel, should certainly give consideration to joining the list of assistants. And I'm just going to pause there and echo what Marie-Hélène said, that the defense team is made up of not just counsel, but also a more or less large group of assistants and personnel. And if it weren't for the team behind counsel, these cases would just grind to a halt. They really are absolutely essential. We have legal assistants, we have analysts, we have evidence reviewers, we have linguists, we have case managers, and it really is a team effort. So if you're interested in work at the ICC and you don't fulfill the criteria yet for being on the list of counsel, do please give very serious consideration to joining the list of assistants. I'm also going to say that being on the list of counsel, for example, does not, well, the people who are on the list of counsel are able to do far more than simply represent defendants before the court. That there are other roles that can be fulfilled, and I'm thinking mostly of opportunities for defense counsel to be appointed by the court to represent witnesses who are coming before the court, for whom there's concern that their evidence might result in self-incrimination. So the texts of the court do make provision for witnesses who are at risk of self-incrimination to be assisted and represented by lawyers before the court. And that's a really, really great way to, get some sort of insight into the workings of the court, to get some experience of working at the court without, having to be thrown in at the deep end as defense counsel. There are other very important roles for defense counsel in terms of assisting witnesses in the course of prosecution investigations. And these are all provided for in the text of the court. So the Star Spangled Banner is going to start playing in about 2 minutes. such as life on a military base in the United States. Before the trial starts, there is there's a very lengthy pre-trial phase at the court. So after an accused person has been charged and summoned, or a warrant of arrest has been issued, and the accused has been arrested and brought to the court, we start a pre-trial phase, and that's an incredibly important phase for the future of the trial. And it's a phase at which defense counsel have a very important role to play. Defense counsel can make all kinds of challenges in the interests of their client relating to the jurisdiction of the court and the admissibility of the case. Now, ordinarily, challenges to jurisdiction and admissibility of a case before the court can be made only once, and it has to be made, generally speaking, before the start of trial. But these sort of challenges are provided for in the text of the court under Article 17 and 18 and 19 of the statute. So just to give you, I'm not going to go through all of the provisions of the text at this stage, but, you know, for example, challenges can be made to show that a case is being investigated or prosecuted by a state that already has jurisdiction over the defendant, or that the case has been investigated already and a decision has been made that the individual is not to be prosecuted. If a person has been already tried by a court in another state, and whether they've been found guilty or not guilty, then the principles of non bis in idem apply, and a challenge can be made to say that a person ought not to be tried before the court because they've already been tried elsewhere. And also importantly, the argument can be made that the case is not sufficiently serious to justify further actions by the court. This is all important, and this is something that defense teams can, and in practice, do when representing their clients in pre-trial proceedings. Another important thing for defense counsel and defense teams to do in preparing for trial is investigations. Proceedings before the ICC are supposed to be hybrid proceedings as between different legal traditions, the common law and the civil law. I think the reality of the situation is that proceedings would be, on balance, more familiar to lawyers who come from a common law jurisdiction. So, you know, the United States, Canada, the UK, Australia, New Zealand, and so on, than for lawyers who are more familiar with the civil law tradition, the Romano-Germanic traditions. And one of the things that defense teams can do is to investigate the charges against their client, conduct defense investigations themselves without going through the court, without asking the court to authorize them to carry out investigations, without having to ask the court to do the investigations themselves. It's a really important obligation and responsibility on defense teams to carry out their own investigations. And that really ought to start at the very, very beginning of the case. There we are, the American national anthem. but that is something that some defense counsel may not have a great deal of experience in, especially if they're coming to the ICC for the first time. So it's important for defense teams to bring on board professional investigators as soon as possible. Now that carries with it its own challenges. So let me give you an example. I've already indicated that I'm defending in the case of Mr. Abdul Rahman in Sudan. The prosecution case is finished. The defense case is due to start. But one of the great problems at the moment is that in Sudan, an armed conflict is raging. In April of this year, essentially a war started between two generals in Sudan. And the reality is that in Sudan generally, and Darfur in particular, because that's really where we want to carry out our investigations, the country's on fire. It is far too dangerous for the defense to go to Sudan. It's difficult and dangerous for people to move around in Sudan, to get to places of safety, to even to get to other countries. So that is making life extremely difficult at present. Another thing that I can say is that cooperation from certain states, and sometimes the state of which one's client is a national, it is important to obtain, but sometimes cooperation is not forthcoming. And that can create other difficulties for the defense in terms of carrying out their duties. So yes, investigation should start as early as possible, but that theory is not always entirely straightforward in practice. I said that proceedings before the ICC would be perhaps more familiar to people who have a background in the common law, because the way the trial proceedings work is that, first the prosecution presents its case, the prosecution call their witnesses. During the prosecution case, after the prosecution have called their witnesses, the victims have an opportunity to ask questions, and then the defense cross-examine prosecution witnesses, very much as it is done in national jurisdictions, particularly in common law jurisdictions. It's not called cross-examination at the International Criminal Court, or the ICC try not to call it cross-examination, but it's questions by the adverse party. The ICC is very anxious not to use terminology that is particular to one legal system or the other, and so a new I guess glossary of terminology tends to be used at the ICC so as to not sort of offend one legal tradition or the other. But really, defense counsel will cross-examine witnesses and test the prosecution case through the questioning of defense witnesses. And that's important because it's through the cross-examination and the testing of the prosecution case that the rights of the accused are protected. The rights of the accused are set out in some detail in the Rome Statute in Article 67, and I suppose at its heart, the role of defense counsel is to protect the rights of the accused. So let me just run through a couple of those, or some of the most important rights of the accused are set out in the Rome Statute. And really, nothing that I'm about to say is going to come as any great surprise to you, because they're the sort of rights that are going to be familiar to any defense lawyer from around the world. but let me just give you a couple of examples. Defendants have the right to be informed promptly and in detail of the nature and cause of the charge against them. That must be done in a language that the accused understands. It won't come as any surprise to you that interpretation and translation from the language of the accused into one of the working languages of the court, English and French, essentially, is a huge part of the work of the court. Defendants, accused persons, must have adequate time and facilities for the preparation of their defense. And again, that is found in international fair trial instruments from throughout history. The right to be tried without undue delay. You may be aware that trials at the ICC have a bit of a reputation for taking a very, very long time. It's not just the ICC. The same was found at the same was experienced at the Rwanda Tribunal, at the Yugoslav Tribunal, at the Special Tribunal for Lebanon, and so on. These cases, by their very nature, are complex, they are complicated, and they take a very, very long time. But a point that is always at the forefront of the court's mind and the parties' minds is the defendant's right to be tried without undue delay. Defendants have a right to be present throughout the trial. Defendants have the right to examine or have examined witnesses against him or her, and to obtain the attendance and examination of witnesses under the same conditions as witnesses against the accused. And the accused have the right, well, I spoke about interpretation and translation a moment ago. They have the right to that interpretation and translation free of any cost. Defendants are not compelled to testify or to confess guilt. So in other words, defendants have the right to remain silent throughout, and that silence will not be held against the accused. And there is no reversal of the burden of proof. What that means is that throughout the proceedings, it is the prosecution who bear the burden of proving the guilt of an accused, and the standard is proof beyond reasonable doubt. And I'll just pause there for a moment. Heidi made reference to the truth-finding role of the court, and of course that is an important element of the role of the court. The court does want to try and arrive at the truth, but I would suggest that the International Criminal Court's principal role is not to arrive necessarily at the truth, but to decide whether the prosecution has proved its case against the defendant beyond reasonable doubt. In the course of that process, very often the truth will come out, but the ICC is not a truth and reconciliation commission. It is not principally a truth-finding institution. It is a court. It's a court of law where the principal question must be, is this particular defendant guilty or not? I'm going to move on to talk a little bit, just very briefly, about what life is like for the defense before the ICC. And it's certainly not without its challenges. Now, some of what I'm going to say is going to apply just as much to the prosecution and the victims. But there are some defense counsel who are of the view that defending an accused person before the ICC is particularly challenging because the defendant faces and the defense team faces something of an uphill struggle. Defendants are brought before the court charged with the most serious crimes known to humanity. They're charged with the most heinous of crimes, the most serious crimes, often with a great deal of media exposure. The court will make a great deal about the fact that person X or person Y has finally been arrested and has been brought to court and will face justice. So, you know, the finger is pointed at the defendant, and there is not institutionally necessarily, but the defense is starting from a position where there is a great deal of presumption of guilt. Again, but in society, certainly. And that brings a great deal of pressure to bear on the defense. Cases I've already alluded to, cases are very, very long. And it takes a great deal of stamina, I think, for defense counsel and defense teams. They take a long time. They are often harrowing in terms of the detail that has to be dealt with on a day-to-day basis. Defense teams are very often made up. I've spoken about assistants and you know, the team around defense counsel. Often experienced assistants, often experienced teams, but sometimes our teams are made up of relatively young professionals who are you know, in the early years of their practice. And it's sometimes difficult for younger lawyers to have to deal with really quite difficult material, difficult factual circumstances that have to be analyzed and assessed and digested day after day, week after week, month after month. It can really take a toll, and I think that that's something that needs to be really fully understood. At the ICC, more is being done to understand about the impact of dealing with this sort of material over extended periods of times, especially for less experienced and younger lawyers. But the same sort of stresses apply to more experienced lawyers as well, I have to say. But it's not always very easy. The work involves a lot of travel. Some lawyers, some defense teams do decide to live in The Hague, but not necessarily. So if you're coming to The Hague for trial proceedings, but you're based and your family is based and your practice is based elsewhere, there's a lot of travel involved. There's a lot of time away from family. So defending at the court is not always great for family life. That can create its own stresses, and also, you know, some lawyers have a great deal of experience in terms of managing big teams, not just doing their work, being in court and defending their clients and cross-examining witnesses and so on, but defense counsel increasingly have to be very good at managing, you know, sometimes quite large teams. It's a skill set that lawyers don't necessarily have. It's a skill set they don't necessarily learn at law school or in practice. And it's something that some lawyers find rather challenging. Now, so I'm speaking to a group of Romanian lawyers. You'll have perhaps more you might be more familiar with vast amounts of drafting in preparations for your cases. But defense practice at the ICC involves a huge amount of drafting, a lot of written work, certainly more than oral presentations in court, I think. So you need to be very, very good at written advocacy, very experienced at written advocacy, and build around you a team that has a great deal of experience in written advocacy. Those are just some of the challenges, I think, to being a defense lawyer at the ICC. I'm just going to finish by saying that there are a great deal of positives as well to being a defense lawyer at the ICC. The cases are, by their very nature, incredibly interesting. It's fascinating work. I think it's one of the best jobs in the world. You get to become very, very quickly an expert in the geopolitics of a region or a country or a part of a country. You get to become an expert in sociology. You get to become an expert in features of linguistics. You get to become an expert in military matters, historical matters, other political matters. And I think international criminal law is an area of practice where law and geopolitics and history really meet. And it's absolutely fascinating. You also get to work with great people from all over the world. You get to work in multicultural, multilinguistic teams. You get to work in opposition to prosecution teams that are multicultural, multilinguistics, and that throws up all kinds of fascinating challenges, but it's very, very enriching. I think I'm going to stop there, but despite the challenges, working for the defense at the ICC is a great job. And if you're not yet on the list, I would very, very heartily recommend that you apply to join the list as quickly as possible. Thank you.
Thank you so much, Ian. That was a really great presentation, even for me, who's doing the same job as you. I don't see any questions in the chat box, but provided you all have microphones, you're welcome to raise your hand or indicate in a way or another that you have a question and actually say it. Anybody would like to ask a question? Waiting. It doesn't look like it. Well,
Please.
I guess every day. Oh, yes, please go ahead.
No, that was me saying, please ask questions.
Oh, I'm sorry. I thought someone was telling me to not move on and because they had a question. I'm sorry, Ian, it doesn't look like anyone wants to raise a question. Maybe everything was incredibly clear. I hope it's also a good sign that maybe you are interested in having more of these opportunities to exchange with ICC practitioners. We would be more than happy to make this a more or less a regular occurrence and whereby we could delve into different, more specific topics. But as there is no questions at this stage, I think this will bring us to the end of the session. Sincere thank you for attending and showing interest in the work of the ICC and the ICCBA. Thank you so much again to our focal point, Sylvia Baerbeck, for organizing and putting us in touch. I definitely hope that this has inspired some of you to apply to be on the list of the ICC, potentially to also become members of the ICCBA and join our international legal community. Thank you very much again, and I hope to see you soon again here online in Bucharest or maybe in The Hague. Thank you.
I've put my email address, my personal email address up in the comments. Please feel free to contact me at any time you like if you've got any questions or want to discuss one-to-one any aspect of the work of the ICC or working as defense counsel.
I've just done the same as well. Thanks for initiating that, Ian. And thanks to everyone. Very nice to see you.